Good evening, ladies and gentlemen. Thank you very much for attending tonight. Great to see some familiar faces and some new faces. Welcome to what we're calling our inaugural Aged Care Summit. We hope that the information you're going to listen to and digest tonight is going to hopefully broaden your awareness and knowledge of the aged care sector. And to help you guys make decisions potentially for yourselves or for family members and loved ones, family or friends. So again, welcome. Just a couple of quick housekeeping notes. If you need to use the amenities, the restrooms, back out the hallway and upstairs. Find gentlemen's and ladies' bathrooms up there. And also in the event of an emergency, please make your way out the same way you came in out that front door. So again, welcome. We're here tonight to discuss all things aged care from the beginning to the end of the year. There's a big process that's involved with understanding that journey. It doesn't start at during residential aged care from day one. It does take a bit of a journey, a bit of a process. And the more you're aware of that process now, as you maybe, like I said, go on this journey for yourselves or for loved ones, hopefully the better decisions you can make, be it financial or for the family at large. So, obviously tonight, anything we discuss here is general advice. What we would invite you to do after is reach out to one of the partners that you're connected with, be it Mirror Accountants or GSR Lawyers or ourselves, Block Depot, and for us to sit down with you one-on-one and give you that bit more direct and tailored advice that will cater to your needs. Okay. So tonight we've got speaking with us a few illustrious panel speakers and guests, starting with Michelle from COASIT. So COASIT are a home support care service that also provide care services in the NDIS space as well. So Michelle's going to talk a lot more tonight about home care, how that works, the journey there, and that sort of process between home support into potentially residential aged care. Joined tonight by Marcus here from Challenger. So Challenger are a large financial product provider. They specialise in providing and building annuities that help support not just aged care strategies, but also retirement income. So really important. We have Mr. Alfio Romano here. Some of you obviously know Alf. Our sort of go-to legal, the man that's been seen a lot in the world, and we definitely lean on Alf a lot regarding our experiences with clients. We have Mr. Michele Romano from Mirror Accountants. Some of you may know Michele, and some of his team are here as well tonight, which is lovely to see. And Michele is going to focus on a little bit of tax strategy and asset structuring in the lead up to potentially looking at entering residential aged care. And touch on some of those trusts and structures that may be available to you. And then I'll round it all out with a bit more understanding about the new residential aged care reforms and how those numbers and those calculations sort of do work. I'm going to invite Mr. Alfio Romano now to come up and talk to us a little bit more about this concept about testamentary trust, which are going to be a very important part of your estate planning, potentially, if you haven't already considered it. So, Al, come on up.
Thank you, mate. Thanks very much. Thank you, everybody. Thanks for coming tonight. As Sebastian said, I'm going to talk about estate planning, in particular about testamentary trusts. Now, I know that's really not to do with aged care in a sense, because it's talking about when you die, but it's a very important thing that everyone needs to think about. You'll see I'm going to talk about a case study scenario just to give you an example so that I know everyone's facts are different. Obviously, you need to get separate advice when you want to look at your own circumstances. But I'm just giving you a simple example of a mum and dad, age 60. They've got 2 kids that are over 18 and they're married, and they've got 5 grandkids, 3 from one child, 2 from another. Okay? That's the sort of standard thing that I come across most of the time. And most people say, they're going to do their will. I call them an I love you will. I love you will means I love you. It's all yours. See you later. I'm gone. Right? That's the sort of standard thing. What most people do is the spouse leaves it to the other spouse. That's the normal thing, first step. And you appoint that person the executor. If that spouse is already gone, the will say now the next step is it goes to my two kids equally in their names, absolutely. Okay, that's the second normal step. And then it'll say that if any of my children have died already and they've left 2 grandkids or 3 grandkids, their share goes to the grandkids. Okay. And usually that's at a certain age, 21, 25, some say 30. Had a client once had about 50 million and he wanted to leave it to his kids when they turned 50. I thought, a bit ridiculous. But anyway, each their own. And then it'll also then go on to say that if a child dies without children, it'll go to the remaining child. Then you'll have a reserve situation where if everyone gets wiped out, the plane drops out of the sky, there's no one left, you normally give it to someone. Most people say half to my siblings, half to my wife's siblings, okay, and all their kids. So that, in a nutshell, is your simple I love you will, okay, which most people set up. They're reasonably cheap to set up, around $500, $600 to get a will done in that nature. Okay. Now, I said, why would you use a testamentary trust and a will? Now, the word testamentary trust is quite simply, it means a trust that's created in your last will and testament, hence the word testamentary trust. There's nothing magical about it, other than the fact that it's created in the will and it only starts when the person dies. Okay? Right. Now, so that you understand what a trust is, if people have spoken about trusts tonight and you might think, what the hell is a trust? What's he talking about? A trust is quite simply, I give the example of, I had McKelly here, for example. I say, McKelly, here's $1,000. I want you to start up a trust where you're the trustee, your 3 children are the beneficiaries. Okay, so he's the trustee, kids are called the beneficiaries. And I say to you, McKelly, you hold that $1,000 in trust for those 3 children. Okay? That's what we call a fixed trust, which means that the 3 children have got a fixed share in that $1,000. Okay. And if I change, I'm going to say, McKelly, instead of doing it as a fixed trust, I'm going to say, McKelly, I'm going to give you the total discretion as to what you do with that money. So that $1,000, you can invest it. Whatever you make out of it, let's say you make $100 income for the year, you've got a total discretion who you want to pick amongst those 3 beneficiaries and give them what you like. You can give $90 to one, 10 to the other, none to the other, whatever you want. That is the concept of a discretionary trust, which is the second thing I mentioned there. So who are the trustees, the beneficiary? In that example, McKelly is the trustee. I could, instead of saying McKelly, I could say, let's set up a company called it Mickey Mouse Proprietary Limited, of which he's the director, and that can be the trustee. Okay. Who are the beneficiaries? Well, you name who the beneficiaries are, normally family members, etc. And that's why they call it a family trust that you hear a lot of people talk about. Who is the appointer? The appointer is the person who's got the power to control the trust by being able to change the trustee. So obviously, if you've got the power to change the trustee, you dictate who runs the trust. And whoever the trustee is determines who gives the money to whoever, you're controlling it. Okay. Hence why I said earlier, where the Social Security look at it, they go, oh, hang on, are you a trustee? Are you a beneficiary? You're an appointer? You must be controlling this thing. That's going to be part of your assets to work out in the pension and all these benefits the government supposedly wants to give us. So I've just mentioned those 3 guys. And now this type of trust I've just been talking about is what I call a living trust created when you're alive. Okay. The testamentary one I just mentioned is only when you die. So they're 2 different types of trust, but essentially they're the same type of trust, the same sort of concept. Okay. Now, one of the things about a living trust is the tax man doesn't like living trusts. He thinks you're here just to try and save tax. So what has he done? Over the years, we used to be able to give our children money under a trust, okay? And the government used to allow us to give children money and the children were treated as if they're adults. So we could distribute income from the trust to the children and pay a lot less tax because the kids could earn up to, say, first 20 grand tax-free, and then 20%, 30%. The government over the years has whittled that down, so now you can only give a child $416 tax-free. Anything over that, you pay a penalty rate of about 40%. So a family trust, a living family trust, is not the great vehicle it used to be from a tax point of view. However, there are still lots of benefits, flexibility, etc., which I won't go into. But the testamentary trust, sorry, I'll skip that one. testamentary trust, you'll see that one of the major tax benefits is that they go back to the old law, which is that children are treated like adults in a testamentary trust. And you say, why is the difference? Because you figure the tax man figures you're not going to die just to save tax. Okay? No one wants to do that. And so he figures if you're setting this trust up in your will, it means you're gone and you're actually providing for your family. So he lets you have the testamentary trust with beneficiaries who are children and can earn income at adult rates of tax, right? Which is fantastic. Right? Why? I'll give you a good example. Myself, it actually happened to me. My mum left us a testamentary trust in her will. She left us a house property, my two sisters and I. We sold the house property. We each made $180,000 capital gain, myself and my two sisters. Okay. If I didn't have this testamentary trust and I had the I love you will, and I got that asset in my name and I got the 180 grand, I have to pay tax on it. Can't do anything about it. It's mine. It's my absolute property, right? Instead, because I set the will up with mum, I became a trustee for my testamentary trust for me, my children, my grandchildren, right? And guess what? I've got 8 grandchildren who are aged between 2 and 18 or 17. So what do I do with my 180 grand? I went 20 grand, 20 grand, 20 grand, 20 grand, 20 grand. How much tax did I pay? Nothing. What would I have paid on 180 grand? Probably about $70,000 tax. Big saving. Thank you, Mum. This is the sort of thing you can do for your kids and grandchildren. Okay. The significant tax benefit I've just mentioned, discretionary distribution of income, you can split amongst the lower tax beneficiaries. Infant beneficiary I've just mentioned, they get up to 20 grand effectively tax-free. And you can also use what I call a bucket company as a potential beneficiary. So if you haven't got any grandkids, for example, you can still have what I call a bucket company, which is just basically a company that is a beneficiary of the trust. Okay. And you can distribute the income from the estate to that company, which one of your kids or whatever own, and they'll pay a flat 25% tax as opposed to you maybe paying 40%. Okay? So it's a discretionary thing, flexible thing that you can use. Okay. I'll just go back to this slide now. This is the mum and dad I was talking about before, and this is a typical thing I get when people come to see me about what they have. And what I do basically is I go through what your assets and liabilities are and what your situation is going to be when you die. In this particular case, you'll see it says principal place of residence as joint tenants, $800,000 was the original cost, value today 2.5. And I say to the clients, what happens if you decided to rent that house when you die rather than sell it? If you rented it, you might get $80,000 a year income, which is estate income if you die. Okay. That might have an investment property, it's joint tenants, worth 650 post CGT, which means you've got to pay tax on it. It's now worth 1.2. The same thing, it's rented at the moment, you're getting $65,000 a year income into the estate. Okay. Superannuation, this one had 300,000 and 150,000. Again, if that was cashed up and you just invest in getting 5%, you'd be getting, that should be 22,000 a year. Life insurance, he's got 1.7 mil, she's got 200,000. Again, you invested that cash. When you die, you're going to get maybe 5% of 95 grand. These people had a family trust business, right? So they had a family trust that I was talking about before, which is a living trust. So this guy runs a business in partnership with his family trust as a partner, and that's worth $2 million. So again, if that was cashed up, you'd be making 5% of that, 50 grand. They had some cash in the bank, 300 grand. If you invested that, you're getting about 15, and there's a liability of $1 million. So basically, these people are worth about $9 million. Now, of course, not everyone's in this boat. You could be a lot better than that, could be a lot less than that. But generally speaking, if you've got more than just your house you live in, then this type of will is something to really consider because of these benefits. In this particular case, you'll see that because on these assets, when they both die, this is the sort of money they're going to be having in the estate, $476,000 per annum. It goes into the estate. If in this case, these guys, so they had 2 kids, I think I said, and 5 grandkids. In that case, this money will go to the 2 kids when they're both gone, right? And they'll be earning roughly $238,000 per each child, which in the simple I love you will means what? Absolutely theirs. goes straight into their account. They have to pay tax on it, $238,000. If they have the testamentary trust, however, in that example I gave you, you've got son 1 and daughter 2, and they've got, let's say, 3 kids and 2 kids. They can distribute this money, this $238,000, amongst their children and try and use them up into the higher tax bracket. So the first 20 is tax-free, then it's 20%, then it's 30%, it goes to 40%, whatever. So what you do is you use up those beneficiaries first, and then when you get to maybe 30%, you then think about using a bucket company as your basic receipt of the income. So you only pay 25%. You see the big difference in saving to your children in doing this compared to if they owned it in their own right, absolutely. Okay, they have to pay tax on it. There's no ifs and buts.
Just to explain on that. So with the kids, obviously the threshold, but then the 2 children that are survivors of the parents, their income might only be 60,000 each as well. So there's a benefit of actually giving extra to them to top them up to the next level as well.
Correct. So what Miko's just saying is, that example just gave the 2 children, the son and the daughter I'm talking about, they may be only earning 60,000 a year, so they can give themselves more income up to a certain amount and then distribute it to the kids. Just basically it's all about using people with lower tax thresholds up to a certain level and then go to the bucket company. Okay? That's the strategy most people use in this sort of circumstance. All right. So we've talked about that. Now, you'll see that next heading, it says bloodline only testamentary trust. Now, a testamentary trust doesn't have to be bloodline only. And what bloodline only means that you're saying, in my will, it says my estate goes only to my children and my grandchildren and my great-grandchildren. Spouses, no, get nothing. Okay? Spouses are excluded. Now, you don't have to have that. You can include spouses. Now, why would you include spouses? It's another person you can distribute income to and save tax. Okay? So a lot of people still have spouses in their trusts because of that benefit. Okay? However, 1 in 2 end in divorce these days. So parents get a bit worried about their kids. And so people then start to think about, why don't we just do this bloodline only? And in our bloodline, we normally include adopted children, because in case your kids want to adopt, or they may not be able to have kids. I mean, we do IVF, for example. You allow IVF. But a strange one where a lady, she had a baby, the donor sperm and donor egg, so absolutely not her blood. And I had to change our rules to cater for that, because technically that child was not a bloodline child. Anyway, so lineal descendants, I've just talked about. Can you include spouse? I've just said that, but I'll lose the bloodline. Keep family assets within the family. What happens if a beneficiary gets divorced? Okay, you'll see it says their trust assets are generally not considered assets or property of the marriage. Okay? Now, what that means is this: if your son gets divorced and he's the beneficiary or the trustee, if you like, of his little testamentary trust you've set up in the will for him, what our will provides is that if he goes into this divorce situation, he has to step out of being the trustee of his trust. And generally someone else will step in to take control of his trust. And it might be the other sibling, it might be the executor, whoever you appoint in the will. Okay? So he steps out, he's no longer the trustee. He's still a potential beneficiary of the trust, but so are his kids and his grandkids and bucket companies and blah, blah, blah. So when he goes to the family court, he says, Your Honour, I'm just a possible beneficiary of this. I may never get anything. And it's true, you may never get anything, because being a beneficiary of a trust doesn't give you any rights, as I just explained in that trust before. Remember I said there's 2 types of trust. One's fixed, one's discretionary. The fixed one, you have got an interest. But we're not talking about fixed trust. We're talking about discretionary. Discretionary means the trustee has a discretion as to who he gives the money to. And you could all be beneficiaries of my trust and never get nothing. Why? Because I'm the trustee, I don't give it to her. You get nothing. And you got no rights. You can't say, hang on, what about me? I say, yeah, I looked at you, but sorry, you get it all. Okay? So there's no rights, you see. So he can go to the family court and say, I've got nothing, Your Honour. I've got a possible, I might get something, I may get nothing. Okay? So the family court goes, okay, yeah, we see that. Not real happy about it. So going back a step into the I love you will, you leave 500, whatever it is, and 9 million to that child, straight into the asset pool. The husband or wife said, you, I want a nice chunk of that. Thank you very much. And the family thought, yes, that goes to them because you married her. You're the pool. You pay her. That's how it works. In this type of trust, no, they can't touch it. Why? Because of what I just said. You don't actually own anything. You're saying, I don't own it. The judge, the family court goes, I like it. See that, not real happy about it, but we'll let it go. But what they do is then the family court in their wisdom, they say, we're not going to call this an asset of the marriage because we see it's not. But we know it's something, you've got something in there, there's something strange. So we're going to give it a different name. We call it a financial resource that you can somehow get something out of. And because you've got that, you're talking to your son who's beginning to look, we're now going to cut the cake between the son and his wife, but of what they own, a little bit more to their spouse, because you got this little thing over here. But the key is that they're not cutting the cake of what you've left your children. It's their cake. They've only got a little piddly house and a car. That's all they can cut. If you left them $5 million, they can't touch it. Okay, and then as soon as he gets out of the divorce, what happens? He steps back in to be the trustee of his trust. Happy days. And he's got his 5 million still. So I find most people prefer this even more than the tax benefit because it is a protection for their children. Okay, particularly the outlaws, the in-laws, we call them. I've got, unfortunately, one of them. I've talked about the control business here. That's the control. You step out of control while you're in trouble and you step back in. That's what that's all about. Okay. Next thing is asset protection for children. Now, this is another major benefit of the testamentary trust. The same thing applies here. You got your son, Michele's my son. He goes into a bad business deal, someone's personal guarantees, goes belly up, they bankrupt him. Okay. Now, what happens in the I love you will? You've left him $5 million. The trustee in bankruptcy goes, you, thanks, I'll take that $5 million, go pay all his creditors. Michele's left destitute. With the testamentary trust, same thing. Michele has to step out. He can't be the trustee while he's bankrupt. So he's there and he says, I don't own anything. I'm just a possible beneficiary. I may get some, may not get anything. And so what happens then? The bankruptcy expires. He steps back in, takes control again. The bankruptcy people cannot touch this because it is not his asset. In the I love you will, it is his asset.
What's the time?
Absolutely owned.
What's the time frame in stepping in and out?
Bankruptcy usually is up to 3 years, but it can be extended if you've been a bad boy and not playing ball with the trustee in bankruptcy. But generally 3 years. Matrimonial, same thing. A divorce and property settlement usually takes 2 to 3 years. Okay. Now, usually, as I say, it's either one of the other siblings will take over the trust. And in our will, provide that the new trustee who takes over can't make, big decisions without getting the approval of the other person. So you can't just run off with the money. You know what I mean? So it's protected from that as well. So you see the 3 benefits there. Okay, the principal place of residence retained by beneficiaries, the 2-year rule, and Michele's already mentioned that you can hang on to the house for 2 years. If it's longer than 2 years, CGT may apply after death. So what we always suggest is that you sever the joint tenancy. Now, people know what a joint tenancy is. Joint tenancy means that if I own a house with my wife as a joint tenant, if I die, she automatically gets the house by the law of survivorship, not by your will. Your will's got nothing to do with it. Okay. Now, if we want to use this testamentary trust, then we sever the joint tenancy, which means we change it from joint tenants to tenants in common. That just means I own my half, she owns her half. When I die, I leave my half under my will to whoever I like. She does the same. And in the will that I was talking about, the testamentary trust, in a similar sort of will where you give it to your spouse first, which most people do, and then spouse not around, then it goes to my kids. That's the sort of standard scenario. The same sort of will is basically what the testamentary trust will does. So in first instance, husband will normally leave his half share of everything he owns to the wife under a testamentary trust. So the wife then owns her half of everything in her own name, and the other half she owns as trustee of a testamentary trust for herself, your children, your grandchildren. Okay. And then when wife dies, her Other half she owned her own name. She leaves that under a testamentary trust to your children. So your kids end up with effectively two, one from dad, one from mum. Elders provide you can merge the two, so you can only have one if you want. You can have two, depends on what the circumstances are. Okay? And so it's a two-stage process. Okay, look, stage one goes to the spouse. Normally, if you haven't got a spouse, obviously normally go straight to the kids. But normally you go to the spouse first, and that's why we sever the joint tenancy, because you want to leave half the house to the wife under the trust. Why? Now you said, well, if you're going to sell it in 2 years, there's no big deal. That's true, but you may not want to. And I've had it occur where, you know, husband dies, wife doesn't want to live in the house anymore because too many memories, but all the kids say, don't sell the house, it's freaking going to be worth a fortune. The Olympics are coming, you know, don't sell it, you know, give it to us, the kids. And that's why they then hang on to it. Now, if they hang on to it, then they're going to rent it, aren't they? So if they're renting it, they're generating an income. That income, then half of it, the wife owns in her own name. She's got to pay tax, can't do anything about that. The other half, she owns as trustee of a trust. She can distribute to the kids and grandkids and whatever. And the capital gain that is made, because you'll be paying capital gains tax on the home you live in if you're renting it out after 2 years. And that's worked out based on a percentage basis on the time you own it. Okay. So the time you own it as a principal place is basically tax-free. The part you own it when you're renting it, you pay tax. Okay. And that's just a proportionate formula, which McKelly will help you with, no problem. Okay, so we talked about that. All right, now this is an important one too. You find a lot of people have what I was calling before a family trust or a family discretionary trust, which is the one I said that the taxman doesn't like, and he only gets you $416 for kids that you can give them money as a distribution of paying no tax. But what do you do with those trusts when you die? Because trusts keep living when you die. Okay? So, for example, I've set up my family trust. I'm running my legal business out of the family trust, and then I drop dead. Trust doesn't stop, keeps going. Okay? Trust normally lasts for 80 years, but now the law changed last year. It now lasts for 125. You can stop at any time, of course, but it can last. So a lot of clients then have a dilemma. What do they do with their trust when they die? And generally, you know, what do? Give the control to your kids. In this example, we've got 2 kids. Giving one trust to 2 children is not a great thing, is it? Why? They're going to make decisions every year who gets the money. And you'll find that if they're both married, they've got husbands and wives in their ears saying, you know, he doesn't go cut the grass at the block of flats. I do that. He's a mongrel, you know, why are we giving him money? And all you're going to have is the kids fighting. So control to the 2 children, not a great idea. Giving control to 1 child, is that a good answer? Possibly, but then what happens? Inequality. He got the trust, I got the block of flats, but his is worth 10, mine's worth 1. Unhappy days. Okay, all shit happens. French. You can have an agreement to say we're going to agree, 2 kids are going to agree that we're going to split the money 50-50 every year. Okay, that sounds reasonable, doesn't it? Unfortunately, the law is that a trustee cannot fetter his discretion. That's the word there, see, fettering discretion. In other words, you can't preempt what you're going to do every year. You've got to say, no, every year you're supposed to sit down and go, right, I've got a discretion. I'm going to consider all these people. Yeah, I looked at him. Yeah, no, I'm going to pick this one. Okay. You can't say, in the year 2030, I'm picking him. You can't do that. You've got to do it every year of the 30th of June. Okay? Now, people still do this and hope they get away with it. And often the taxman doesn't check. They don't really worry. Because remember, everything is self-assessment. When you lodge your tax return, taxman believes everything you say. Till he audits you. Then he doesn't believe anything you say. So, you know, you could have this voting thing, but I don't recommend it. Another one you can do is cloning the trust. Remember cloning the sheep, that thing? Same sort of thing. You've got a trust and you can say, let's set up a new trust, call it a clone number 1, right? And I'm going to transfer half the assets from this trust to this trust. So now this trust owns half, this trust owns half. I'll leave this trust to son, this trust to daughter. Good, isn't it? Because this guy runs his own show, she runs her own show, right? Only problem with that is you're actually got to convey half the assets to this trust. And what are you doing then? You trigger capital gain on money you don't actually get. Okay, because you're transferring half an asset to this trust. Okay, and there'll be capital gain to pay tax on, and potentially stamp duty, which is over 5%, which is not just what we sneezed at. So again, cloning, not real flash. Hybrid trust, creating a hybrid trust to manage your interest. Again, I've got there will attract CGT. It's a similar sort of thing, but what in that case, what happens? You've got a discretionary trust, which we talked about, the simple family one. And instead of having the discretion, we changed the trustee to say from now on, we're going to create 2 units, if you like. One unit is like a share, it's going to be held by him. One unit is going to be held by him. And each of those units can decide who amongst their family group they want to give the money to, and he decides amongst his family group. That's what's called a hybrid trust. But to do that, the tax man says he believes that that's creating a capital gains tax event on which you pay tax. So again, you're paying tax on money you don't actually get. Waste of time, really. And look, the final one then is probably the only one that's most logical, and that is vesting the trust. That means wind it up, sell everything, cash it all up, right? And then give it to your kids in their testamentary trust. Because then they've got the benefits of the kids earning up to 20 grand, etc., which they don't get in these trusts. Okay? So that's the one most people opt for. Is it easy to run? I said, yes, absolutely. Bank account setup, tax compliant. So it's pretty simple. I know it looks complicated when you see these documents, you know, the will's about 30 pages long and there's all this garbage in it about how it runs and all the rest of it. But it's basically pretty simple in the sense that, you know, husband and wife, husband drops off the perch, wife comes in to see me, so what do I do now? So it's quite easy. Get the will that we prepared, go down to the bank. So see this will, it says, I'm the trustee, the wife, I'm the trustee of the Mickey Mouse Trust. Open me a bank account. Bank opens a bank account. So it's, you know, Mary Smith as trustee of the Mary Smith Trust. She comes back, what do I do now? It's easy. See all these assets we got over here? Half of them are going to you now under this trust. So whatever you got to do, cash up, whatever it's super, money in the bank, whatever, put it into that account. And then with that account, go and do things. What do you want to do? Invest it. What do you want to do? End of the year, you come and see McGelly for your tax and say, here's my bank statement, what do I do now? He says, no, I'll prepare you a trust tax return. Okay? He does that, works out what the income you've earned from that money you've been left in the estate, works out the income and says, right, what do you want to do with it? So I've got 3 kids, I'll give them that. Oh, what else? Oh, let's go to the bucket company. Yeah, beautiful. Finish. That's it. Next year you start again, do the same thing. Now what happens when you both go? Kids come in and do the same thing. So go down and open the same will, don't have to go any more documents, nothing more to prepare, and open a bank account as Bill Smith as a kid, as trustee of the Bill Smith Trust. Same thing, you then put everything into that account, and he does exactly the same thing. So it's not rocket science, it's pretty straightforward, really. That's it. One thing that McGelly mentioned and everyone's mentioned is this 5-year thing. And I think you need to always consider that very strongly, depending on what your ages are and where you're at in life. But if you're going to plan, you've got to plan for it as early as possible. Don't wait till it's too late. Then you're at 65. You can, as McGelly said, and they all said, you know, you give away $30,000. It's ridiculous. In other words, you can give it away. They still treat it as if you can give away $1 million, but they'll still treat the $970,000 as yours, even though you've given it away for asset, for pension purposes, etc. So you've got to do all that, preferably before you're 60, so you can get rid of whatever you want to get rid of and reduce your estate assets, which is what Sebastian's going to talk about shortly. Finally, I haven't mentioned here, but everyone should have an enduring power of attorney, and if you don't have one, then get one. Why? Because if you don't have one, the public trustee can take over your affairs. You might think your spouse can look after you. They can't. The only way they can look after is they have to apply to the QCAT, the tribunal, to be appointed your guardian. And unfortunately, you're competing with the public trustee. And you've got to convince them, the tribunal, that you'll do a better job running their financial affairs than the public trustee can do. And guess what? Courts tend to think the public trustee is pretty good, even though he's pretty crappy, I think. And they usually get the Guernsey. So if you don't want to have that happen to you, then have an enduring power of attorney. to me, it's an insurance policy. You keep it in the drawer, hope you never use it, as long as you don't lose your marbles. But if you lose your marbles, it's there. Someone's going to be looking after you financially and health-wise. Very important document. Now, that's a document separate to the wills, obviously nothing to do with the will. Power of attorney is when you're alive, wills when you die. All right. Any questions? Yeah.
Is the with setting up the testamentary trust, is most of the cost in setting it up, or is it ongoing?
No.
And then, so is the best age, like that example that you gave? How old are they, for example? Like
That was 60, but look, there's no.
the people my age set that up.
Oh, yeah. Look, as I said, the question is more, what's your asset position? If you've got 2/5 of nothing, obviously not much point. If you've got something, you've got a reasonable asset base, no matter what age you are, and you've got kids, you can be 30, you can be 35, doesn't matter. If you've got something, if you've got nothing at the start, you've got your stereo and your record collection, not so good, But anyone who's got a reasonable asset, they've got a home they live in, and if you've got an investment property or something like that as well, or you've got your super, you've got whatever you've got, then it's worth considering that type of will. Now, extra cost? No, there is no extra cost. Once you set this will up, hopefully it can sit in concrete for the rest of your life, because the will basically say everything I own will go this way. You don't have to say this house goes to that kid and this one goes there. You can do that, of course, but if you do that, if that house is not there when you die, then that gift is useless. That's why most people just say leave everything in particular proportions or shares. Okay? But no, there's no extra cost. And as I said to you, the will is it. You don't have to go get another document drawn up. Whether it applies to the spouse in the first instance or to the children, it's all in there in one document. Same document goes to the bank, you open the account. That's it. And then the only ongoing cost is the annual trust tax return, which we can bill it at the account.
So just to clarify that, so if Ian bought another property.
Yep.
Doesn't have to change or update the will or
If our will said everything I own when I die goes to wife, she's not around, my kids, they're not around, my grandkids, which is basically I love you will, just that we've transported it into this testamentary trust concept. And so when they get it, they're not getting it in their own name, they're getting it as trustee for all those people. But they run it, they control it, it's their baby. They do what they like with it. If they don't want to give it, like if you say I give it to my wife as trustee and she says stuff the kids, I'll give it all to myself, she can, because she's the trustee. She can do what she likes, totally discretionary. Right? Yeah.
Do the properties have to be put in a trust name, or do they remain in your personal name?
Eventually on death, remember the will only starts when you die. The property stay in your name until you die. When you die, what actually happens is, there's a period, what we call the executor's year, where executors are supposed to collect the assets, pay the bills of the estate, and then give it to whoever the will says to give it to. Okay? That's what's called the administration or executor's period. Okay? When that period's over and he's done his bit, he's paid all the bills, paid the tax, whatever had to be done, and he's now got the assets left, he then is supposed to transfer it to the beneficiary. In this case, if the beneficiary is a testamentary trust, it goes to that person as trustee. So you could find a property, for example, say you're leaving your assets to your 2 kids, right? And say I'm the executor. You leave it to the 2 kids, so I'm the executor. So what happens is when you die, that property of yours gets transferred to me as what's called the personal representative of the estate or the executor, right? I pay all the bills, whatever. Now, sometimes the beneficiary say, we don't want to keep the property, sell it. So the executor sells it, gets the money, whatever the money is then, and then gives it to the beneficiary. Or if it's not going to be sold, after the executor's year's up, basically, the executor then says, right, now I've got all the assets, everything's been paid. Who am I going to give it to? Oh, your 2 kids, right. So I'll now transfer that property from my name as executor to their names as trustees of their respective trusts. So it'll be Mickey Mouse as trustee of his trust and Donald Duck as trustee of his trust. On the title, that's how it will show. Okay. And when they look for the trust, it's in the will there. And the will actually gets lodged in the titles office. People can see it, search it.
just in Danny's case. So say, for example, he's got a couple of properties in one property trust, another couple of properties, another property trust, a couple of in his personal name. Same situation, right?
Well, the ones in the property trust he's talking about, you've got this problem. Hang on. That one. What do you do with those properties? Because they are not in your will. Do you understand? They are not your property, not your personal property. They are your trusts, your living trust. Remember I said there's a living trust, the testamentary trust is in your will. If you've set up a property trust that owns 3 properties, right, and you die, what happens to that trust? These problems. Do you give it to the 2 kids? Do you give it to 1 kid? Do you give it to, where do you give it to? Right? That's your choice. Now, in most scenarios of a property scenario, let's say you two, your husband and wife, eh? Yeah.
53 years.
You poor bugger. One of you. In a normal property trust that just owns property and it's husband and wife, you don't really need to do much. So if you drop off the perch, what normally it'll say is control of that property trust goes to her. Okay? The question then becomes then when you're both gone. How many kids you got? 1, 2. There you go. You're going to leave that to the 2 kids? Are they going to have these fights? Is he going to say, you didn't mow the grass, I mowed it, why should you get the bloody money? That's what happens. I've seen it happen. Believe me, I've been doing this for 45 years. I know exactly. So you don't want to give them that risk of fighting about it.
Give us some clues on what you do.
What you do?
Yeah.
Well, as I said, basically
No,
vesting.
no, if they don't talk to each other. Give us some clues on. What do we do? Do we leave one out of
Oh,
the
no,
will?
look, leaving one out, that's another headache and a half.
Well, yeah.
Let me just give you a quick thing on leaving people out. Even if you, as you may or may not know, we have a law in Queensland and in most states that says that if a child or a spouse feels that they have been left without adequate, the words are maintenance and support, adequate maintenance and support. That's what the government put in the law. What does that mean? Whatever a judge thinks it means. And basically what it means is that they're saying, Mum and Dad should have left me more. So even if you get 50-50 and 2 kids, one of them can say, hey, I should have got more. Why? Because I need it, and the other one doesn't. And the court, in their wisdom, can actually change your will and give them more. Right? And you think that's ridiculous, but that's our law. Why did the government do that? They don't want to pay pensions to anybody or unemployment. They want you to look after your own kids. It's a horrendous law, but it's there. So if you're ever thinking about cutting a kid out, think twice. Even when you give them equal, you still got a problem risk that they could still try and go to court over. You're gone, at the end of the day, they fight, they're going to fight between themselves. Nothing you can do about it. And what happens is if, say you, the property trust, you said, if we both go, then I want the trust to best, which means it's got to be sold. Whatever the assets of the trust are, they sell it, cash up, pay the tax, and then you give it to them and they do their own thing under their own trust. See? And people say, oh, I've got to pay tax now. I said, yeah, but hang on. Some way down the track, you're going to pay tax, aren't you? All you're doing is bringing it forward when you die. You know, big deal. And you can put in the will also that your 2 kids can bid to buy the property off the trust. Because remember, they're going to get half of it anyway. So they're only buying half of it. And I put provisions in wills where they say, you know, we'll put it in a hat and whoever got the best offer wins. Sort of thing. I get it. Because you get that sort of rivalry. I've seen that happen too. Terrible. But yeah, so they're all the problems you got in wills that you need to think about. That's about it. I think. Anyone got any more questions?
You mentioned one downside, I think, downside of a testamentary trust where the wife gets everything and decides she's going to keep it all herself.
Yeah.
Are there any other downsides?
There is one downside that if a property goes into a testamentary trust, the land tax you pay is at a higher rate because natural people pay land tax to a threshold of 600,000. Over that they pay. Trusts at that threshold of 350. So an extra 250 grand land tax you'll be paying. That's a negative. But you don't weigh up. You can't have your cake and eat it all the time. So that's not so bad. If you're worried about your wife running off and marrying a Filipino bloke, then you need to think about what we call a contract for mutual will. Right? What that is basically, husband and wife's prepare their wills, say it's going to go to each other, then the kids and the grandkids. Then they sign this contract that says we're never going to change those wills unless we both agree to change them or we get divorced. The reason for that is then that if one of them decides to marry a Filipino and they change their will and leave it all to Filipino, the Greeks could be Italian, could be anybody.
Italian just kill them.
Then what happens is if they do change their will, the estate of the person who signed the contract, which is usually the kids, can sue the other person's estate and say, you breached the contract. You suffered us loss because what we were supposed to get now is all gone to these guys. I want you to pay me the damages. Now, it's a tough case to run, I can tell you, because, you know, you can't stop your spouse from not spending the money. Right? You know what I mean? If they want to spend the money on themselves and have a good time, well, that's fine. But the idea of it is it's more like a stick to make them sort of realise that, no, they're not doing it. We also say in that document, if they're going to form a relationship with a third person, they have to sign a financial agreement with that person that says they're not going to touch what you've got in your estate. Okay? That's just another stick. Again, it's all contract, breaching the contract. Properly. Yep.
And during power of attorney, when would somebody not require one? I mean, like you said, not if they don't have assets and they're young, but you know, if they're getting into middle years, would it be an idea to do the thing?
Oh, look, everyone should have one.
Should everybody
from
should
young, even these young guys at the back here. I had a secretary in my office. Her brother was 21, fell off a horse. He was in a coma for 12 months, and they had to keep going to the public trustee. Can I now pay his bill for this? Can I now pay his bill for that? You know,
What's it cost for power of attorney?
power of attorney is about $500. Good investment. Insurance policy.
Set it once and for all.
Yeah, well, you can change it as long as you don't lose your marble. You can revoke it and add people, change it, whatever you want to do. But if you lose this, you can't change anything. If you lose this, you also can't change your will. Although there is a provision under our legislation that allows a person to make an application to the court for what is called a statutory will, where a judge can actually make a will for you if you've lost your marbles, if he can be convinced that you would have made that sort of will had you had your marbles. Right? And a good example is, let's say, husband's lost it. Wife comes in and says, I'd like to do this will. It sounds good. I've got the simple will. I want to change to this. And so the wife changes to that. And she says, my husband would have done it too if he had his marbles. And say, good, let's go to court. So we go to court. We say, Your Honour, look, the wife changed it. That's what she wanted. And it's quite obvious he would have wanted it too. Will you change it? He said, yep. And he makes the order and creates a will, not signed by the guy, but it is a will that binds the estate. Yeah. Unfortunately, it's a costly exercise, but. All right. Anything else? Sorry.
Can you structure your will so that the beneficiaries can decide whether to receive their share through a testament trust or direct?
Yep. And answer that. He said, can you have it where I don't want the testamentary trust? Yes. Quite simply, the will say, if at any time beneficiary says, I don't want the trust, I want my money. If you don't, you get done. That'd be foolish. But yeah. Why would you want to do that? It's crazy. Just another quick thing I'll tell you. What happens is, in this example, you give the money to your kids, and say you left them $3 million. What do most kids go and do? They'll go and pay off their mortgage. Or buy a house. Now, if they go and buy the house with the money you just left them in this bloodline testamentary trust, what have they just done? They've converted what you've protected into something that can be attacked by the wife spouse. But how do you do it? What you do when they come and talk to me, I say, no. What you do is you, wearing the hat of the testamentary trust, lend the money to yourself and take a mortgage back for the money, so that when the spouse ever attacks you, you've got a nice big fat debt, has to be paid back to the testamentary trust. The family court can't touch it. Right? The equity, of course, will maybe go up, and they can't stop that. But see, those little tricks they need to know, and that's why, everyone's saying, I don't want the trust, they'd be fools. But, stop.
What sort of money are we talking about to set up?
I charge $4,000 plus GST per will. about $8,000. To assist my clients, I break that bill up, half of it as tax advice, because you'll see I've just given you a heap of tax advice. And so that's tax deductible to you. A lot of food for thought.
Well
Okay.
done, Al. Thank you very much. Al.
Thank you.